It's a pleasure to welcome you on this virtual, seminar. And I'd like first to welcome you on behalf of the law faculty of the University of Geneva, the China's Journal of International Law, the European Society of International Law, and the Grotius Center for International Legal Studies at the University of Leiden. So as you all know, we will be discussing the topic I quoted, the normative powers of United Nations Investigative Mechanism. So these few words of introductions are going to attempt to place the discussion in a sort of broader context. And when we speak of, in fact, investigative mechanisms, we speak of a very specific dispute settlement mechanism. And it's a specific dispute settlement mechanism, which is in fact fact-finding. And looking at history, and I think it's always important to look at the past to learn about what we can do. In the future, it was interesting for me to go back to the works and the conferences of the Hague conferences of 1899 and 1907. And it's interesting when you look at the conventions that fact-finding was one of the most important dispute settlement that was sort of included by the member states in the Hague conventions. And fact-finding was as important as conciliation and arbitration, the newcomer on the international scene. So it's interesting because states attached a lot of importance to fact-finding at the end of the 19th century. And one question, and we will go back to all this during the discussions with our two panelists, but why was it so much interest behind fact-finding? What is the rationale behind fact-finding? And I think that it was thought that with fact-finding, you could have an objective and impartial investigation of the facts at the origin of a dispute. Okay. So this objective and impartial gathering of facts at the origin of a dispute would help resolve the dispute through other means, be it negotiations or other mechanisms. So at that time, I think it's also interesting to stress that when people were speaking of fact-finding, they were speaking of facts, and they severed law from facts. Facts could be delinked, as if we could use a trendy word today, could be delinked from the law, okay? And what is interesting, if you look at the practice, is that in fact, we didn't have many fact-finding experiments for resolving interstate disputes. But in the few that we had, what we see is that there was a problem with the links between facts and law, okay? And because there were issues of qualification, there were criticisms of the investigations as conducted. So this was the origin in the 19th century, in the course of the 20th century. Now, what is interesting is that even though you had these problems, investigation became an important dispute settlement mechanism in the field of human rights and in the field of international humanitarian law. And I would like to add, because I was thinking about it and looking at other fields, I think that in the field of development assistance, financial institutions too, investigation plays an important role. But it's quite different from the one that we're going to be discussing today. So interestingly, nowadays, when we look at what the use of fact-finding, of investigation, we see that there is a blossoming, and Ginevra Le Moli, who is going to present her study, her in-depth study, has shown that there is a blossoming of mechanisms that have been put in place since, in fact, the early 60s. That's when she started to look at all these mechanisms. And more interestingly than the number is the fact that right from the beginning, there was no issue about these links between facts and law, it seems to be, okay? So that it was accepted in humanitarian law, in human rights, that you could not really delink the facts from the law, that there were issues of qualification which would arise, that in fact, and Ginevra has shown that in her study, when you look at the mandates which were crafted by the member states of the United Nations, they were also asking them to qualify some of the facts in legal terms. So this, I think, is something interesting, is that in a way experience has shown us that there is a tight relationship between facts and law and legal qualification. So that's the first point I'd like to make. Then the second point, which comes from reading Ginevra's paper, is that, in fact, when we speak of the law, we should have a broad understanding of what it is, because it's not just the substantive norms, but in fact, the investigative mechanisms have also shaped procedural law. And at the University of Geneva, for example, we work a lot on evidence issues, and it's quite interesting that investigative mechanisms have shaped their own rules in relations to evidence and probabilities and so on. So that's another issue, and the burden of proof might be a topic of discussion when we discuss, because obviously when you have an investigative mechanisms, the parties are not there to present their positions. So is there an issue of due process or not? That is maybe something that we can discuss. Then the following idea that came from reading the paper was also that if this relationship between law and facts has been endorsed, I think it has been endorsed, there is a subsequent question which relates to the understanding by investigative mechanisms of the scope and the extent of their normative powers. Okay, and in this context, and maybe it's because I work now quite a lot in dispute settlement, but I was wondering, so what's going to be deciding about the fact that some investigative mechanisms might have exceeded the boundaries of their mandates, and who should be the ones to decide? And it seems to me, and I'd like to discuss that with Ginevra and Larissa when we will have the Q&A session, is there a possibility for the Commission to decide that they are able to decide, they have the competence de la compétence as a power to decide about how to interpret the mandate, or should it be their parents? And when I speak of their parents, I speak of the Human Rights Council, I speak of the General Assembly, I also speak of the Security Council, because the Security Council has also created some mechanisms. So those issues are interesting. And then I was wondering, so maybe investigative mechanisms together with the parents, so there could be a shared responsibility. This is something that scholars in Holland like to extrapolate. So we can also discuss about these issues. But you see, what I think is very interesting, and I'm very happy to have been asked to introduce the discussion, is that the questions which arise in the field covered by Ginevra Le Moli, in fact, are broad. They are broad because they are shedding light on a mechanism that I think has been forgotten in other fields of international law. And that could be also another question, is that why is it so much, is there so much emphasis on investigative mechanisms in the field of human rights, in the field of international humanitarian law, but less in other fields? And I read, when preparing, I was reading at some of the first experiments, and they were in the law of the sea. So why the law of the sea has forgotten about this mechanism and has looked at other mechanisms. So though you see a lot of questions which arise from reading the very good article that Ginevra Le Moli has written, and which is published in the most recent issue of the Chinese Journal of International Law. So we will have a discussion. I'm going to introduce Ginevra first. Ginevra is an assistant professor of international law at the Grotius Center for International Legal Studies at Leiden University. She is also the chair of the interest group on international criminal justice of the European Society of International Law. And she, among other things, because she has done already a lot of things, she's conducting a full-time research project at the University of Geneva and Cambridge. And the theme is also of great interest. And I'm sure that investigation is also going to be very important. The theme of her research is illicit traffic of natural resources. And you know that it's very often the cause of a lot of conflicts. And we think of different examples. So Ginevra is well versed in international law. She has diplomas from almost everywhere in Europe. She's a true European scholar with a PhD from the Graduate Institute of International Studies, a master from the University of Roma, a diploma from the London School of Economics. And she has a certificate, and I'm jealous of it, I must say. So I'm going to mention it. She was granted the advanced certificate on preventing the next pandemic from the Harvard School of Public Health. And I must say that going through the current pandemic, I just want to avoid and prevent the arising of another one. So that will, it's not going to be a topic of discussion today, but we can discuss it further at other occasions. What I also like to highlight with the profile of Ginevra is that she has been in the field. And I think it's very important to be discussing also this mechanism. She was a consultant with the UN High Commissioner for Human Rights. And she took part in UN investigation teams in Syria and Yemen. And I think it's also an account of the field is also going to be very important when we discuss this type of dispute settlement mechanisms. So without further ado, Ginevra, it's my pleasure to give you the floor. Thank you.
Thank you, Laurence. And also, I would like to just thank you for the kind introduction, but also it's really a pleasure being with all of you today. And I would like to thank the University of Geneva, the staff of the university, and also in particular Professor Mbengue for hosting the conference and for also the availability and also enthusiasm showed in supporting this event. I would like also to thank the three other co-sponsors, the Chinese Journal of International Law and also the European Society of International Law and the Grotius Center for International Legal Studies. I am going to just use few slides, so just bear with me a few seconds so that I can share my screen with you. All right, so I hope you are all able to see the presentation. So now in my short presentation today, I would like to discuss the outcome of a quite systematic study, as Laurence mentioned, and it has been a study on normative powers conferred on and exercised by all the investigative mechanisms set up by the United Nations between 1963 and 2020. I conducted this research in the past 2.5 years, and I finalized it during my research stay at the University of Geneva between September 2020 and December 2020. And it has been now published on the Chinese Journal of International Law. So in the following 20 minutes, I would like to first present the analytical framework developed to analyze the investigative mechanisms, mandates, and reports. Then I will somehow move from the static description to the dynamic description of the development of investigative mechanisms, normative powers over time in both mandates and practice. And last, I will offer a general assessment of the evolution of these normative powers, also pointing to several possible extensions of the research. So let me start first with a few clarifications in terms of method and also base of my study. It's first necessary to clarify also the term investigative mechanism and the expression normative power. So the term investigative mechanism refers to all the international bodies that have been tasked with fact-finding, inquiry, investigative, or advisory missions, which share mainly 4 functions. They have been, and features also. They have been established by international bodies. They also have a temporary or extended mandate. They gather facts about a situation or investigate human rights violations, often engaging with international legal issues. And lastly, they are non-judicial bodies and their findings and recommendations are not binding. So as regards instead the expression normative power, or normative prerogative, as I also mentioned in my study. It encompasses a gray area between, at one extreme of the spectrum, the mere power to gather fact, and on the other side of the spectrum, instead, clearly conferred powers to judge a conduct and derive its legal consequences with binding effect. So in my study, I refer to the philosopher Hume famous dichotomy between ought and is. That is not possible, according to Hume, to deduce ought, namely a norm, from is, fact, a fact. So again, this observation is merely a shortcut to locate the context in which the study unfolds. What I aim, my main purpose was to try to analyze the gray area in between, because indeed investigative mechanisms do have the power to gather facts, but they cannot formally compare a factually established conduct to an existing primary norm of conduct, and in case of violation, derive the legal consequences defined by secondary norms with binding effect. So the space in between is quite wide, and in my study I therefore decided to really build an analytical framework to chart the gray area in between, and find a structured analysis of all the mandates of 69 investigative mechanisms that have been set up since 1963, and also analyze the reports, in total 121 since then, adopted by and published by the same mechanisms. So this first figure shows the starting point, my cartography of investigative mechanisms' normative powers. And I relied on these three broader types of powers, which relate respectively to first, the establishment of facts, the assessment of primary norms, and lastly, on the powers about secondary norms to guide the more granular survey of both of both mandates and practice and reports. And just to give you briefly a clarification of this chart, under the first type of normative powers, powers about facts, namely we can see three subclusters. First, the power to gather facts about a situation. Then in power A2, that I define A2, the power to gather facts about a situation with a pre-characterization in the mandate in a non-legal or legal manner. And power A3 instead refers to the power to gather facts about specific conducts and with a legal pre-characterization, but that is included in the mandate. Then in the cluster B, we have powers about primary norms. And here, once again, we have three further subtypes of normative powers. Namely, the first is the power to take a position on enabling normative conditions, such as, for instance, the definition of the threshold and the very possibility for armed non-state actors to be bound and hence be capable of violating human rights law, or the standard of proof, for instance. The second subset, B5, is instead concerns the power to define or interpret a relevant primary norm. And the last one instead is B6, is the power to characterize a conduct as a specific violation, of course, without binding effect. So this leads me to the last category, the category of powers about secondary norms. And here we have the power to characterize the conduct of a collective subject under C7 or under C8 of an individual subject with the general or specific recommendations. And the last one, C9, which is also quite rare and as I will explain, it cannot be found in mandates today, is the power to characterize the conduct as a violation and derive in legal terms specific consequences of breaches of the law. And so in the article, I supported also all this map with specific illustrations. I'm happy to explain them further during our discussion, of course. But for now, what I would like to do is simply to move from the static description to the more dynamic description of their evolution over the period of time. This leads me also to the second part of my presentation, where I will identify their development and the developments of this power, the development of these powers in mandates and also in the actual practice. So this figure, this is the second figure, instead summarizes the results of applying the analytical framework to understand major step changes in the mandates of 69 investigative mechanisms. And so the dark gray quadrants that you can see represent newly introduced normative powers. So powers not conferred to any previous investigative mechanism. And so somehow they represent more visibly what I call step changes, while the green quadrants represent powers previously conferred to investigative mechanisms. And so the broad brush trajectory that you can see from a sole focus on factual powers to a synchronous focus on two, and then all three types of powers emerge quite clearly. And as does also the move from a less to a more far-reaching subtypes of normative powers within each overall type. And but more specifically, this figure and this image, and that is the outcome of a long study, also shows three important lines of development. Because between 1963 and 1992, mandates conferred mostly powers over facts. And between 1992 instead and 2000, we have an increasing recognition of broad powers relating to primary norms and also to secondary norms. While the powers related to secondary norms sees an expansion mostly after the year 2000, powers instead over primary norms see and undergoes a similar expansion after 2012. Again, unfortunately, given the time, I cannot really explain them in more detail, but I'm happy also to develop also with a few illustrations, also this map and the outcome of this map also later in our discussion. Instead, now I would like to simply move to development of normative powers in the actual practice and try to present the main outcome. So there are certain discernible patterns that can be inducted from the practice of investigative mechanisms in relation to the exercise of normative powers, and in particular with regard to primary and secondary norms. So what I defined as powers B and C. And in particular, overall, two main patterns emerge from the analysis of 121 reports. There is on one side the display of evaluative reasoning related to primary norms, while the display of prosecutorial reasoning with regard to secondary norms. And all in all, we see a clear expansion over time, which also partly reflects power expressly conferred in mandates, and in other occasions instead powers that go beyond what expressly conferred. So I would like to spend a few words on each of these two reasonings. As regards the evaluative reasoning, the expressions found in practice are diverse, certainly, but they all share one common feature, that is the assessment of a conduct in light of a prescription of prohibition derived from international law. And in particular, I would say, and I quickly go back to the first image, that is the starting point, that there has been a substantial practice on the clarification on enabling conditions, namely threshold matters or the standard of proof. So what I would call B4, while to a lesser extent also a practice related to the interpretation and definition of specific terms, what I define as B5. And I provided examples in my study with regard to application of human rights law to armed non-state actors, to the determination of the standard of proof, and also the characterization of different types of armed groups, so the definition of armed groups that is normally not provided in the mandate, but is then instead expanded within the reports. As regards instead the prosecutorial reasoning, and this relates to the cluster of powers C, as I defined them in the chart. Investigative mechanisms seek to prepare the stage for the next steps in the chain of accountability processes, whether this is expressly envisioned in their mandate or not. And in particular, the practice shows an increasing use of powers, so-called the C7 and C8, so the expansion of making recommendations of a general or specific nature in their reports. But mostly we can see and hear two cross-cutting patterns once again. So on one side, the recommendations of criminal prosecutions before national courts of the territorial state, and the second instead, the recommendations to trigger international responses before courts of other states exercising universal jurisdiction, or before the International Criminal Court or ad hoc tribunals. And there are also two minor patterns. On one side, the use of an integrated approach, so a combination of both recommendations to the state, or also recommendations and also recommendation at the international level. And most recently, I would say, the reports tend to call UN member state to also assert their right to react against unremedied breaches of international human rights law or international humanitarian law, by way of, for instance, imposing individual sanctions or refraining from supplying arms. So the last instead subcluster, namely the power C9, is displayed in some reports, but this power has not been fully integrated in mandates. Partially so in the mandates of the IIIM for Syria and the IIM for Myanmar. Why it is so? Because they have the power to specifically prepare case files in accordance with international law standards. And in this way, they facilitate fair and independent criminal proceedings. So somehow we can say that they show that the internalization of the preparation of criminal files is a new step forward by UN mandates in the promotion of accountability. And so certainly this power is closer to that of an investigating judge or a prosecutor who sets the facts, the indictment, and the requested legal consequences. But the practice of these mechanisms is not yet ripe enough to draw clear conclusions as to their scope. But we certainly here, we reach the border area with the acknowledged prosecutorial powers held by domestic and international courts and tribunals. So to conclude, what is all this discussion telling us? Well, first, a general conclusion is that although investigative mechanisms do not have the power to characterize the violation of primary norm and derive the associated legal consequences with binding effect, they exercise a wide range of normative powers, some of which come very close to what judicial bodies do. And more specifically instead, there are discernible step changes in the overall phenomenon, whereas between 1963 and 1992, mandates conferred mostly powers over fact. Starting in 1992, instead, they began to recognize broad powers relating to primary norms, and from 2000 onwards, also to secondary norms. In particular here, some specific powers not expressly conferred in the mandates have been widely exercised in practice. And this relates mostly to powers relating to primary norms. And a third and most fundamental trend is the increasing number of investigative mechanisms that have been set up since 1963. And in the 3 decades, for instance, between 1963 and 1991, only 5 mechanisms were set up and established. Then in less than a decade, between 1992 and 1999, more than twice that number were established, 13 mechanisms. Then it further accelerated the phenomenon because between 2000 and 2010, 20 mechanisms were created. And lastly, there has been a little surge in the newly established mechanisms between 2010 and 2020. 31 new mechanisms have been created, so which brings the total number to 69. So in conclusion, the gray area between the is and ought has been increasingly populated by a wide range of normative powers conferred on entities, which at their origin were only concerned with the facts that also Laurence mentioned in their kind introduction. And so an important question which my study raises at the very end is whether, in fact, international criminal justice is moving not from is to ought, which rather reflects the normative powers movement within the system of investigative mechanisms, but paradoxically, in the movement from ought, international criminal prosecution, to is, so the softer approach of investigative mechanism. And so I intend to explore this less empirical also question in a sequel study. For now, I thank you for your attention, and also I look forward to our discussion or to answering any questions or curiosities that you may have. Thank you.
Thank you very much, Ginevra. So thank you very much for this introduction, which has shown that there is an increasing number of investigative mechanisms, but there is also an increasing number of questions and legal questions that come at the forefront. And I think I'm sure that we will go back to some of them in the discussions. But without further ado, I would like to introduce Professor Larissa van den Herik. I must say that I'm very pleased to welcome her to this webinar. I have great respect for the work of Larissa van den Herik. She's a professor of public international law at the Grotius Center for International Legal Studies at Leiden University, and she has played a lot of key roles in this university. And I think it's really thanks to her that international law is so much at the forefront at Leiden University. So the fields, the areas of expertise of Larissa are many, but I'd like just to, because we're going to be discussing a lot of the issues in relation to the paper presented by Ginevra, she writes a lot on peace and security issues, on the sanctions, on the international criminal law, and she has written one of the key articles on fact-finding missions a few years ago, and which was published, if I'm not wrong, in the China's Journal of International Law. She's now, presently, she has changed a bit the focus of her research, and she is writing and researching on diasporas and international law, and I would say that it's a very intriguing topic, and I would very much like that we have another webinar dedicated to this topic. So that's an initiative to be conducted by our director at the university. Larissa is also the chair of the advisory committee of the on public international issues of the Netherlands government, and so she advises the government, the Dutch government, on a lot of issues in relations to the topic that we're discussing, and she's also advising the government on issues in relation to the codification of international law at the International Law Commission. You see that the wealth of knowledge of Larissa is very broad, and I'm very pleased to give her the floor. Larissa, the floor is yours.
Thank you very much for this very kind introduction. I'm very happy to participate. I feel a little bit in Geneva, and that's a feeling that I cherish now that we can't travel at all. And I'm of course also very happy to have this conversation with my dear colleague Ginevra of Leiden on fact-finding mechanism, investigating mechanisms, or commission of inquiry, which is a line of research that we have been doing with a number of people in Leiden. Catherine Harwood has written her PhD on this, but she has now left us. So I'm very happy that Ginevra is here, and with this very important line of research. And it's true that I also published on commission of inquiry in the Chinese Journal of International Law. And Ginevra and I, we come actually to quite similar conclusions in our respective articles. But of course, it's true that my article was very traditional in a way. And what Ginevra brings us is a very innovative research method and way of looking at these commissions of inquiry. So I think also, and we could see it, of course, from the slides, but I think in addition to discussing the theme of the article, I think it's also very interesting to discuss the research method that she uses and that she brings to us. So in my journal in the Chinese, or in my article in the Chinese Journal, I looked in particular at this dichotomy that you also referred to, Laurence, between, let's say, the old-fashioned commission of inquiry as they were introduced by Martens in the Hague conventions, and I contrasted them with the newer type. And as you mentioned, Laurence, we see this difference with the traditional commissions, that they didn't engage with law. They really did not explicitly want to engage with law, whereas the newer ones, they do. But I think there was also another difference in that Martens explicitly said these commissions of inquiry, they were also meant to create a cool-off period, a waiting time to make sure that there was no immediate action, that states would not get into a deadlock because of their impulses, on the one hand. And I think these newer commission of inquiry that Ginevra is looking into, they have actually the exact opposite purpose, because they want to prompt different actors into actions. So they want to alert about what's going on, and they want to make sure that action is happening. And for that very reason, they also use law and the strongest forms of law to make sure that there is follow-up action. So I think there are quite some differences between those two. Now, as I said, Ginevra, what you bring us in your article is this very new approach of looking at commission of inquiry, this more empirical approach, which, of course, for lawyers is very often outside of their toolbox, so to say. And we have had a symposium of the European Journal of International Law that also proposed to look at commission of inquiry more with through empirical lenses. But then they looked at those commissions with the questions, what difference do they make? So they looked at the impact of commission of inquiry on the ground. And you do something different. I think in your article, you do something really unique, because you build this database. You don't look at one commission of inquiry or commissions of inquiry after 1990. You look at all these commissions of inquiry and you bring them together in this database. And so you're not concerned necessarily with this question of legality, legitimacy, desirability, that as international lawyers, we are traditionally engaged with, but you want to charge this phenomenon, and you want to identify the different powers that these commissions or investigative mechanisms acquired over time, and you want to trace the evolution. So it's a very different method, I think. And so first I thought maybe in our conversation we can discuss this method and learn from you and how you did that. And I think one of the notions that you also referred to in your presentation just now is this notion of step change. So you identify step changes as important moments where we see a certain evolution. So my question to you would be, can you tell us a bit more about this notion? With new methods, of course, we also get a new vocabulary. So what is this notion of step change? It's a step towards what? Is it a step towards accountability? Have you also seen steps back? Have there also been steps that were not followed, for instance. So maybe you can tell us a bit about that notion, but also share some further examples with us.
Absolutely. Thank you, Larissa, for your questions. Because they also, the first on the method also allows me to really somehow explain a bit the backstage of this study. Because as you also mentioned, I felt that there was an important body of literature that explored the increasingly frequent resort to investigative mechanisms and the measure of accountability and the recourse to accountability in their recommendations. And the focus of these contributions were on a specific mechanisms or on some selected examples, or perhaps on even more the criminalization of commissions of inquiry. So I consider this assessment as reflecting the East-to-Ought dichotomy, and as I explained, but I also have wanted to try to attempt and begin an overall study of the normative powers. So, and inevitably, this implied adopting an empirical approach. So how did I go about it? Well, I have to say that the most difficult part has been to prepare the analytical chart with all the different powers. I did it by way of induction. So I first collected all the reports and all the mandates. Then I read them all. I took notes, traced common patterns, also dividing also internal sentences by way of logical analysis, like you do when you translate Latin or ancient Greek, is probably when this is an heritage of my high school. And then I allowed the cartography to become mature, because inevitably I had to leave it and develop it through time, and take some time in order to see also what wasn't a common pattern, but was going back, or what was something that was not linear compared to a previous approach. And once formed, I reapplied the cartography in coding each mandate and report again. And this application also made visible further questions that I answered in the study. So have there had been any step changes, or what patterns do I see? And when I mean step changes, I mean turning points or peaks in the beginning of the mandate to actually apply with some certainty specific power. So, for instance, one of the certainly groundbreaking mandates has been the one of 1992 that set up the commission in Yugoslavia. And then we have certainly what I notice is that most of the time my work has been spent on groundwork, but writing the paper took me some time, of course, but less than the research time. But certainly this cartography can be applied to some types of research, but this was specifically triggered by my hypothesis that was, can I prove from East to Ought? And by way of this study. So, my map is quite granular, but can be even more granular, of course, if taken, if the lens is one case study or few case studies, because inevitably the issues or the categories tend to expand even more. But all in all, it allowed me to provide the analysis that followed. So the development, the analysis of the development. And the step changes, as I just to go back to your second question instead. This was, I would say, as again one of the consequences of my first analysis on the chart. So I wanted really to try to trace the process and the development, and I was quite open also to see no developments at all, in the sense that I was open to try to see what if in reports I could see some evolution or not, but also, as I said, the returns to previous forms of mandates. And just to give you a few examples, as early as 1963, the mandate of the UN fact-finding mission to South Vietnam conferred the power, and I quote, to ascertain facts of the situation in that country as regards relation between the government of the Republic of Vietnam and the Vietnamese Buddhist community. So here we are not, where there's no reference to law at all. It's ascertain the facts of the situation in that country. Then between 1973 and 1992, we have, here we have a step change, as I mentioned, but that covers a quite long range of time. In 1973, we have the mandate of the Commission of Inquiry on Mozambique that conferred the power to carry out an investigation of the reported atrocities. So it is used the term atrocity. It is not used the term violation of human rights law or violation of humanitarian law. The first time that we see this term is with the mandate of the Commission of Experts to investigate the situation in the former Yugoslavia. Here, the mandate refers to grave breaches of the Geneva Conventions and other violations of international humanitarian law. So we see that there is a granular change, but it is one of the first. And in order to then crystallize and consolidate in mandates, it will take some time because it will only somehow be after the year 2000 that we will see powers over primary norms and secondary norms consolidate more with more stability in the mandates. For instance, the commissions of inquiry of Syria for Syria, or the mandate of the Commission of Inquiry in the occupied Palestinian territory in 2000 was an important mandate for as regards powers over secondary norms. I don't have the time to go through all the mandates, unfortunately, but I just wanted to give you some examples that shows also the substance of this maybe too theoretical chart.
Yes, thank you. So I have another question also on notions, because of course, if you build a database, it's very important to decide which entities you include and do not include in the database. Now, in your article, you refer to this problem of terminology. So there are always different names for these entities: Commission of Inquiry, fact-finding missions, and you use the term investigative mechanism to bring it together. And I think it's a logical term. It's probably influenced by the endpoint where we are now with the IIIM and the mechanism for Myanmar. And it also makes sense in an article about normative powers. But there is, I think, a deeper question whether Commission of Inquiry and fact-finding mechanisms are really fundamentally the same as those two new entities that we see for Syria and Myanmar. So of course we can group them all together, but we could also say that these international mechanisms, for Myanmar and Syria, are perhaps better grouped in a different bubble with international criminal courts, because those are all entities that are solely concerned with establishing criminal accountability, maybe in a binding fashion, non-binding. Of course, as lawyers, we always think that dichotomy is the most important, but maybe we should have a more thematic approach and say, you have those entities concerned with establishing criminal accountabilities, and then you have a Commission of Inquiry that are concerned with criminal accountability, but also with a broader range of issues. And they look at the law, but they do still also establish facts without direct implications for the law. They look at responsibilities in a broader sense, and they offer recommendations also to other entities, not only with the aim of establishing accountability, but also with different aims of seizing a conflict, for instance. So there is this question, and you recognize it in your presentation, in your article. You recognize that these mechanisms for Myanmar and Syria, you say they are in the border areas, or they're very close to prosecution. So you recognize it, but how did you deal with these questions of categorization?
Yeah, thank you for this point, for this question, because it was at the very origin also of my study, inevitably, also in the choice of what reports and what mandates to consider. And I certainly consider specific features. So those that I also mentioned at the very beginning of the presentation. So I wanted to look at bodies that were created by international bodies that had specific powers to gather facts and or also to investigate human rights violations, and also that could advance recommendations in a non-binding manner, of course. So inevitably, by taking also this broad approach, I had to consider all the commissions and all the entities that have been set up within that period of time between 1963 and 2020. It also allowed me to see more visibly the process. Because if we look at also the mandating bodies, they tend to be the General Assembly, the UN Human Rights Council, the UN Commission on Human Rights, or the UN Commissioner for Human Rights. And so the mandating bodies have been certainly different, but the outcome allowed me, and to in order to prove the hypothesis, I wanted really to see all of the bodies and entities that have been created. And it is true that, as you also mentioned, that the last power, the C9, somehow is certainly somehow a representation of a power that is only explicited and exercised by investigative mechanisms by only two, the IIIM and the IM from Myanmar. I have to say that also the Commission of Inquiry on South Sudan has quite broad powers as well, and has been quite innovative also in its reports compared to others. But this is why, by seeing, and I completely see the nuances between and the differences also between commissions of inquiry and investigative mechanisms. And but I wanted to simply provide a full picture of this evolution. I also want to add that certainly there are different works that have been done also that flag these differences between investigative mechanisms and commission of inquiry. And in particular, Catherine Harwood, and also in her book, flagged the fact that the creation of these investigative mechanisms does not mean that also UN fact-finding missions or UN commissions of inquiry will be displaced, because they still provide some flexibility. They still provide and allow also to have and allow these commissions a broader approach in their analysis. So I think that it's an important point that, if you allow me, I would simply add a few words. Also allow me to expand more what has been added in my conclusion. So the passage from ought to is. So why do I say this? Why do I conclude with this statement somehow? Well, it's because somehow when I concluded my work, I actually felt and that all these materials certainly showed that there was an approach towards accountability. But if seen from the perspective of international criminal justice, is that one could say that potentially the movement is from ought to is. And so as if this increasing movement also towards accountability came at a price, and not a minor price, but a high price as well, because the trend towards the creation or trust in international criminal tribunals has somehow receded. And it seems that there is an underlying impression also in the vast body of literature that also on the topic regarding this recognition that this creation of fact-finding mechanisms is really with softer approaches provided by the UN mechanisms to accountability is becoming a trend. So again, I explored it further because it was already a longer article, a longer study, so I couldn't explore that, but perhaps that would be for another work, less empirical one, but that will certainly complement this one, and perhaps will allow also this consideration that you made to be clarified even further.
Yeah, I think it's a very important point that you make, if we look from the perspective of Commission of Inquiry, the IIIM is the strongest version. But of course, if we look from the perspective of the ICC, the IIIM came because there was no referral to the ICC. So it's the softer version, which brings us a little bit back to Martens in a way, in the sense that these commissions are being used as cool off, or as a moment to slow down rather than to accelerate. And that brings me actually to my last question, and maybe then we can open up. But that is about the parent bodies, because of course in your database, your analysis, you focus on the different types of normative powers. And you look at all those bodies established by UN organs, and you appreciate, of course, that there are different bodies, but obviously you can't take too much variables into your database, because then you can't identify patterns. So I understand that you group them, but maybe now you can elaborate a little bit on the nature of the parent body and what that says about the development of normative powers. So I think the Security Council, some of the step changes can be related to the Security Council in the 1990s. But I don't think that there are so many step changes related to the Security Council of more recent date. And in contrast, I would suspect, but maybe you can elaborate on that, that it's actually the General Assembly maybe that is becoming a bit more active, also with stronger normative powers, so creating step changes as a means to correct the paralysis of the Security Council. So can you perhaps elaborate a little bit on the parent organs, and then particularly, of course, we have the Human Rights Council, but it's quite steady, I think, in its approach. But then these other UN bodies, I think they're quite interesting, and also the evolution of how they created these bodies over time.
Yes, thank you. I will try to be brief. So, but I just two main points. Certainly, the focus of my study was mostly on the normative powers. I had to also make some selection and decisions, also in what was going to be in my analysis and in my study. And I also wanted to clarify that there were also the possible question could have been also, is the mandating entity going beyond its own powers? So but certainly this was going to lead to other possible points, namely consent by the state, or the need for an overriding authorization, again, of the, for instance, of the UN Security Council. So I didn't want to take that route, and really to focus more on the charting the normative powers. I certainly, as I also mentioned in the paper, the Human Rights Council played an important role. But as I traced, I left some of this part of the analysis in the paper when I refer, for instance, to prosecutorial strategies of investigative mechanism. For instance, as regards Syria, let's take Syria. We have in 2012, 2011 and 12, the Commission asking the state to react, to investigate. Then in 2013, no action from the state, and the Commission starts to call the international community to intervene. And also the Security Council between 2013 and 2017. We have many years of calls from the Commission itself to intervene, to do something, and to also refer perpetrators to justice. And only in 2015, the Commission attempts to call the attention of the UN General Assembly. And the UN, in order to refer the case and to adopt a resolution in which it would have requested the Security Council to refer the situation to justice. But what happened is that the UN General Assembly had to, and decided in December 2016 to set up the IIIM. So we see also a chain of perhaps also liabilities, responsibilities from different international bodies, but inevitably also a chain of different responses in order to find a new solution, a new because the IIIM has been an innovative mechanism within the UN system. So, and thanks to UN General Assembly, this has been created, and it led later to the creation of the IIM from Myanmar. So it was certainly a landmark case, but we don't know whether in the future there will be other IIM setups, also because they are quite costly. What the mandating entities have been various, but somehow they have tried to perhaps fill gaps that other organizations, other bodies could not fill or somehow answer. So I don't want to take more time, because this could also lead to further, it could take too much time. And I would also like to perhaps hear some, I don't know whether there are questions from the audience, or but really thank you, Larissa. Thank you, Larissa, for these questions. And certainly I will develop also these points in my follow-up study, I would say.
Please do.
Thank you.
I'd just like to thank Larissa and then Herik and Ginevra Le Moli for their conversation. And that, I think it was also very inspiring. I already have a lot of questions, but I'm going to be giving back the floor to Professor Mbengue, who is the Director of the Department of Public International and Internationalization at the University of Geneva. Makane, the floor is yours.
Thank you very much. Thank you very much, Professor Boisson Chazournes, for the excellent introduction and moderation, and also many thanks to Dr. Le Moli and Professor Van den Herik for this very exciting and stimulating exchange. We are now coming to the Q&A session. I see that we have already a question, several questions in the box, and there is one of the participants here who would like to come back to one of the questions that was raised by Professor Boisson Chazournes in an introduction. And that question is in relation with the role of due process and compétence de la compétence before mechanisms exercising such power, so before investigative mechanism. So could you maybe say a few words about this, Ginevra?
Yes, so I have to first, like, maybe I can answer with 2 points. First, the idea of this study was to really trace what is in the mandates, how powers are exercised, and also how they are implemented in practice. So there is one aspect that was the focus of my analysis, was the passage from is to ought, but in what is also visible, in the sense that what if the moment that you take mandates and reports as your grounding work, what you are not looking at is how these mechanisms actually do investigate, and how do they adopt and take evidences, how do they interact with possible victims, what kind of protections do they follow. I knew that from my personal experience, but that cannot be applied to all the mechanisms, because the mandates tend to have specific guidelines. Each commission tend to follow the guidelines also that they receive from the organization, but inevitably there may be also contextual and historical changes. So from 1963 and until 2020, the differences have been many. Especially today, we consider if we consider the also technology that has been introduced and used even more in the gathering of evidences. So this is why, with this somehow preliminary remark, inevitably I must say that this aspect of the due process has been not fully considered because of this reason, because I tend to only look at what was available in public and what was to the public, what was on the websites of the organizations. but definitely with another type of research that would be perhaps on a case-by-case basis, more specific, and that would also imply some interviews with people that have been engaged in this types of work that would have been also part of the frame. But instead, what was also part of what Professor Boisson de Chazournes mentioned was the aspect of who should be the one deciding when there is an excess of power and when we are going beyond what is in the mandate. And here I can answer in two ways. First, by looking at my research, I did not consider what was implicit or beyond what expressly conferred, because we also have to make a distinction between what is implicit and what is beyond. And what is beyond expressly conferred, it can be traced by way of a metric that defines what is implicit and what is beyond what expressly conferred by way of legal analysis and a doctrinal approach. But, and this is why when I refer to for instance, the specific commission of inquiry went beyond what expressly conferred, I can make one example. The case in which commissions of inquiry defined armed non-state actors. I found and I traced classifications of, for instance, the definition of pro-government militia, rebels, anti-government militias. And all these definitions are never in the mandates, or mandates never expressly define armed non-state actors. And the reason is because, and I believe is also quite understandable, they don't want to narrow down the scope of the scope for the commission, so that they can have more liberty and more freedom in the implementation of the mandate. But we do find it in the report. So we also see that the commissions tend to instead, they are willing to engage in an exercise of clarifying their own mandate somehow. So in case of who should be the one deciding, I think that we have, in case of excess, and again, we have to first define what is excess, of course, but if we define it and we know what is beyond the mandate, then I think one of the clear examples that we have in practice is when courts, also the International Criminal Court, decided to refer to one of the reports of the commissions of inquiry and engages with it, and also decides to disregard the report, because this has happened, especially in dissenting opinions of different judges, when they also show the reasoning behind having dropped a report of a commission for maybe, because maybe it wasn't, the commission was not independent, was not impartial, or it wasn't transparent enough, or there were not criteria on how these evidences were adopted. So somehow these courts can be a way of telling us when the mandates may have been, or the reports have been exceeding their mandates. But at the other levels, the Human Rights Council perhaps could be a platform, but we don't have clear examples yet, I would say. Perhaps also Larissa has something to add on the part of, I don't know.
Thank you, Ginevra. Yes, I was going to turn to Larissa actually to ask her what is her view of the role of due process in general in these fact-finding mechanisms.
Yes, thanks. I think this question of due process became in particular very relevant when these commissions started to use criminal law language. So when you saw criminal law language, let's say, migrating from the courtroom to these commissions, there were these questions: should then not also due process guarantees migrate along, so to say? And I think in particular, when then these commissions, at some point, there was this step change, if we use it, which I don't think was followed through, but when commissions starting to name individuals. And then, of course, this question became really pertinent. But I do think it has broader, it has broader reach than only in relation to the use of international criminal law. And there's actually quite a good writings of Mike Becker on this, particularly in relation to the Myanmar proceedings that we now have at the ICJ. And of course, there we also have this question of to what extent can the ICJ rely on, in particular facts, not so much legal reasoning, but in particular facts. And we see that the ICJ has a preference for facts that are established in an adversary procedure and not unilaterally, so to say. So I do think that there's a question of there's a question of interplay. And if we see more types of litigation at the ICJ that have this human rights element, what will be the effect of that on the procedures of Commission of Inquiry and on the ways that they exercise their normative powers? So not only in relation to international criminal courts or domestic criminal courts, but also in relation to other judicial fora. Yeah, so I think it's pertinent question, but it's an open question. But I do think that Commission of Inquiry have made very important steps, and I think those are also steps that Ginevra is tracing in her article, and I think it's very important. And you see that, for instance, now a panel of experts that are bound to sanctions committees are adopting those processes that Commission of Inquiry have developed. So there is a broader ripple effect of these developments, which I think is very important.
Thank you very much. I think Laurence would like to jump again on this very fascinating and intriguing issue of due process.
I was thinking, because listening to you too, and working a bit more on the Security Council, there is currently this Code of Conduct initiative where states, about 120 states, have committed to not vote against a resolution or use a veto when there is crimes against humanity or genocide which is committed in a country. And I was thinking that, for us, the big question is how are they going to be defining what is the situation on the ground? And do you see a role for the commissions of inquiry or investigative mechanisms for helping the member states of the United Nations to decide when they should be implementing this code of conduct? And just another question now that I have the floor is Larissa, you have put a lot of emphasis on the notion of non-binding, okay? And results. And I was just thinking about the addresses of the reports of these mechanisms, and Ginevra has alluded to them. So you have the ICC, maybe the prosecutor of the ICC also, but you also have other addresses and the national judges. They could also refer to this. So do you think that this non-binding issue is really an issue, or is it more the non-adversarial process which is an issue? Thanks.
Please, Larissa, go ahead.
Yes, no, I think what I try to say with referring to non-binding is that as lawyers, we always think that this is a very important dichotomy, binding or non-binding. But I think we have to realize that this is something peculiar to us, and so I would underemphasize that actually, and I think that even though they are non-binding, the reports in a technical sense, the due process considerations are very important, precisely because of the effects that they may have in other binding or non-binding settings, but also for just reputational matters. So I think non-binding is less relevant, but I do think this process is very important. And if we want these the output of Commission of Inquiry to have effect, also, for instance, in these kind of highly politicized settings of the Security Council, it is in our interest to make sure that the facts are adopted. And the facts are adopted if the process is such that states feel compelled to adopt them. So I think process is extremely important, and if there is some adversary element in that, if there is some possibility for all the actors to have their input in the way the facts are established, and in rebutting facts, I think that's quite important. And in a way that brings us back by Martens, because Martens had this idea of commission of inquiry where you had this arbitration style panel, you know, where facts were established or constructed through a panel where the parties had their say. Whereas, of course, these commission of inquiry that Ginevra is looking at, they are more imposing facts in a way. And, you know, there's the extent to which you can impose facts is very limited. So I do think, and that's why I thought the opening of this panel was excellent, because it's very instructive for us to look back to history and to learn from it, actually.
Thank you very much, Larissa. I would like to continue because we have some other comments and questions in the Q&A box, and I would like to jump back on what you were referring to, Larissa, as new language being introduced in these reports, in particular language from international criminal law. We have one of the participants who thinks that sometimes while conducting research for the future potential prosecution and writing their reports, fact-finding missions introduce new concepts. And one example is the concept of passportization that has been used in the fact-finding mission report on the situation in South Ossetia in 2008. So the participant would like to know how can such effects of these mechanisms be limited? Because in the example of passportization, actually it led to accuse Russia of using a policy without solid grounds. And so the participant is wondering how can we limit such effect of these mechanisms, for instance, in using new concepts. Ginevra, would you like to say something?
Yeah, absolutely. Also, just one word on also the point that Professor Boisson de Chazournes made. I also would like to consider that certainly all these bodies require the consent from the state in order to be set up somehow, because that's also important to take into account, or to also states tend to also allow access or not to the commission in the states to make specific investigations. So the element of binding effect at time has been somehow the underlying condition in order to avoid binding and a binding impact on the internal policies and that therefore an impact on the state sovereignty ultimately. But the deterrent effect of a recommendation of a report is still important to remember. So in order to go back instead to this question on the language, this certainly leads me, in order to see this question from a broader perspective, to my chart, where I included under the cluster B of powers over primary norms, and in particular the power B4 and B5. The B power that I defined B5 is the power to interpret the terms that are in primary norms, and or also the power to clarify conditions, like the threshold for unknown state actors to be subject to human rights law, or the standard of proof. So the Commission has the mandate perhaps to assess the violation, let's say, of international humanitarian law or international human rights law on a specific country. But then it has to expand and interpret the mandate in a way that it also clarifies and attends to and is more contextual based. So this is why in my study, I noticed that there is somehow an overstepping from the commissions of inquiry. Also, by way of just an example, in the decision on the grounds for considering armed non-detectors capable of committing violations of human rights. This is something that is nowhere in the mandates, and you have instead lengthy, huge sections within reports where commissions tend to clarify why we should consider that de facto control can be one of the grounds, or why peremptory norms should apply to armed non-detectors, or commitments undertaken by the armed group itself, for instance, also have been considered relevant. So you see that the context play a major role in this case that that the participant mentioned. Inevitably also this was contextually driven as a solution, but we can certainly include it in one of the exercise of and somehow empowerment of the commission.
Thank you very much, Ginevra. We have a very interesting question from Catherine Arwood in relation to the question that you are posing at the end of your article. At the end of your article, you are actually raising the question of whether international criminal justice is moving not from ease to ought, but possibly from ought to ease. And then Catherine would be very interested to have further elaboration on this intriguing question. But Catherine's question is also in line, is also going in the same direction than what Floristan is asking, because Floristan is also wondering what role do you see for other types of accountability mechanisms, such as state responsibility or domestic civil proceedings initiated by victims in domestic courts to gain a remedy or reparation, once again in light of your assertion that international criminal law, criminal accountability is moving from ought to is.
I'm very glad also to have the chance to elaborate more on this point. Of course, I was at the very beginning a bit divided. I wasn't sure whether to include that in the piece or not, but ultimately I decided to leave it out. It was going to be a bit too broad otherwise, the scope of it. So because I started with the idea that I wanted to map the normative powers that embodied this rising accountability. And certainly I can confirm with my empirical study that, for instance, that the initial commissions of inquiry were dispute settlement commissions mostly, and while the new ones are much more about accountability. But yet, as I worked through all the details of the mandates, I started to read them in a different light, because this is why I really consider that the impression that one could also see, I could also have, is that we are having a move, even though very light compared to what has been the bulk of all the entities created before 2016, that somehow marks the creation of the IIIM for Syria. But we see this movement towards accountability, and we could see that somehow, as also Catherine Harwood mentions in her book, there are somehow outsourced criminal investigators. So in the sense that they are in charge of creating files that will go to perhaps that will end up on the desks of some of the judges before the ICC or before national courts, mostly because the idea is also to facilitate national courts. So I haven't fully, of course, examined the movement from ought to is, but another study could explore the history of the movements in the international criminal justice system from 1963 until today. So a movement from international criminal prosecution to softer approaches that are provided by UN mechanisms, but still capable of supporting some form of accountability. Can be again from ad hoc tribunals to the ICC and hybrid courts, also to an increasing number of mechanisms that are not judicial bodies, and this should be also clear, but tend to exercise more and more normative powers related to secondary norms. So as regards the second question instead, briefly, I wouldn't see any clash or any conflict in with, for instance, the concept of state responsibility, not at all. Indeed, they are complementary, and most of the times what we see is that in recommendations, also commissions and also fact-finding missions have addressed states, for instance, have also addressed and supported and called for actions from the state at the national level by way of national courts, or by way also, as I mentioned, imposing sanctions, or by way of putting an embargo on arms. So you see that there is some complementarity, and so I wouldn't see that as a possible limit, this movement towards accountability. Rather instead simply a support toward accountability.
Thank you, Ginevra. I would like just to raise the last question, because I think it also relates to one idea or one point that was raised by Professor Boisson-Chazournes in the introduction. It is again from Catherine Harwood, who's wondering whether when you were categorizing the normative powers, did you identify any divergences in the written mandates, and how the investigative mechanisms interpreted their mandates? And if you have identified such divergences, how did you approach them in your analysis? Thank you.
Thank you. Certainly, this is a very good point, because it was at the very origin of my study, and I had to make decisions, and I simply that's why it took a lot of time, because I had to create sort of a set of expressions also that could fall, that could create one category, not that could create, but that would indirectly create the category. For instance, I can make a few examples. When I refer to pre-characterization in the mandate of a specific conduct in a non-legal or legal manner. When I notice, for instance, that mandates used to use the expression massacres or assaults or atrocities, these are these are expressions, of course, like others, to say or to imply possible violations of. But of what? Of human rights law, of international humanitarian law, of international criminal law? That's not clear. Instead, what we see is an increased approach after 1992 of the use of human rights violation, of international humanitarian law. So that made things also easier for me on one side. But inevitably, I had to also show and make that distinction visible. And this is also goes with another example, that is the use of the term abuse for violations committed for behaviors inconsistent with the human rights law by armed non-state actors. Because the use of the term violation inevitably leads to a consideration that is almost legitimizing the entity itself. And given that it's so debated in the doctrine, commissions and also mandates tended to use the word abuse. And instead now it is still the term abuse is used, but it is more solid, the use of the term instead, violation. Also in cases when the mandates refers to abuse, the commission then in the reports use the term violations at times, not always. But so it's certainly a granular analysis, and that's why I would give you a lot of examples, but it would take me, we would stay here until dinner, so I wouldn't suggest that.
Thank you so much, Ginevra. I think we are now coming to the end of this virtual conference. Thank you again, Ginevra, for sharing with us this fascinating paper. I think that it is a very original and so provocative contribution, and those who have read it and those who will read it also, I'm sure, will share the same sentiment. I think that the methodological framework that you are offering in this paper is not only relevant for the UN investigative mechanisms that you have dealt with, but it also allows to really explore the whole constellation of normative powers of other investigative mechanisms, for instance, inspection panels established by development banks or other institutional financial mechanisms. So when reading the paper, I was actually thinking that it would be good to maybe even think about turning this contribution into a book, because I believe that it really put the foundations of something broader in the constellation of investigative mechanisms. So thank you again very much. Of course, many thanks to Professor Van den Herik for having initiated a very stimulating and exciting discussion around your paper, and to Professor Boisson Chazournes again for fascinating introduction with a lot of food for thought as usual, and very nice moderation. So I was very happy that we could have this virtual conference. I would like to thank also Ines Mesek and Patricia Doni for the excellent organization and excellent handling of all the technical and logistical aspects. It was really, I think, a pleasure for the Faculty of Law of the University of Geneva to host this conference, but also to collaborate with the Chinese Journal of International Law, with the European Society of International Law, and last but not least, with the Grotius Center for International Legal Studies of the University of Leiden. I hope that we will have in the near future other opportunities to collaborate. I'm very also excited, Larissa, by the topic of diasporas and international law, and it's a very high topic, high issue in the agenda of the African Union. So I'm thinking that I might bother you very soon to organize a virtual conference on this issue together with the African Society of International Law. So thank you to all. Many thanks to the participants, and I wish you all the best, and I wish you all to stay safe. Thank you very much. Goodbye.
Thank you very much.
Thank you. Bye.